Okay.
So, hello everyone. My name is Brian Warens. I'm a shareholder at Lavelle Law. So, I'm head of the practice group that does estate and trust administration. Nataly Kaiser, who you see here, and Jonathan Lee work with me in this group. And we'll tell you a little bit more about their experience as well. So we, Lavelle, we're a full service law firm. We've been in operation for 30 years. We have 35 attorneys between Schaumburg and Chicago. This is a picture of all the happy faces that manage this firm. So, everyone kind of works in a particular group, estate planning, probate, employment law, labor law. So these are kind of the areas that we try to cover pretty much everything. The only areas we don't cover are immigration and patents. So we do some on intellectual property. We do copyrights and trademarks, just not patents, because that's like its own specialty. So we all believe in an integrated approach in this firm. So that means that if there's one of us who can't handle a client's particular issue, we can just pick up our phone, walk down the hall, find the person that is the most able to do a particular project. We work with them to get things done in the most efficient way possible. What separates us from other firms, we're relatively large for a suburban firm. There's not many. I mean, we may be the largest since there's 35 of us, but we strive. Our message is that we try to create value for our clients at incredibly reasonable rates. So you're not paying city attorney fees, but you're getting the same quality work that you would get at a downtown firm. I feel like we've been successful at that for many years, and hence we've grown from a one attorney tax firm, back in the 80s to the current 35 attorney firm that we are today. Yeah, so that's kind of a little bit about Lavelle. And I told you a little bit about me. I'll tell you a little bit more. I've been at Lavelle for 11 years, and my area of expertise again is estate and trust administration. We also I do estate planning as well. We have a very large estate planning team at this firm. There's probably close to 10 of us now that do that type of work out of the 35. So it's a huge focus for us. And Nataly, how about you tell us a little bit about yourself?
Sure. Thanks, Brian. My name is Nataly Kaiser, and I also am an associate here with Lavelle Law. My area of practice is actually in contested estates and estate litigation. And that's basically when the planning hasn't worked out or there's a dispute involved with the estate and you are going through court and basically trying to resolve that dispute in a court proceeding or in a settlement of some kind. And I've been with the firm since 2019. And I do a lot of work with Brian and Jonathan, bouncing ideas off them and how they would handle a particular issue in their drafts or in their estate planning. So we have that nice dual approach of knowing when things break bad, this is how it unfolds. And then when things are planned properly, this is what it looks like.
And hello, everyone. My name is Jonathan Lee. Thank you so much for joining us today. I'm an associate attorney at Lavelle. I joined in May, and it's been great so far. I do focus on estate planning and estate administration work, which includes probate and guardianship as well.
Perfect. So just as another disclaimer, obviously, anything that we say here, since we're the lawyers, we got to do this. Whatever we say tonight's not legal advice and doesn't create an attorney-client relationship, but we offer free consultation. So if you have, any personal questions or personal matters that aren't discussed tonight or you don't want to bring up tonight, we're just a phone call away and happy to meet with anyone to talk through their issues. So this is kind of our overview. here, guys. So we're gonna kind of break it up a little bit. So we're gonna start with, what happens to your assets when you die, and it, there will be, if you have a will, if you don't have a will, if you have a trust and you don't have a trust, we're gonna kind of talk through that whole process of what it looks like and what a good plan will look like, that won't result in issues for intended beneficiaries. So I'm gonna do the first segment. I believe Jonathan's gonna do the second segment. I'm gonna come back for the third, and then Nataly is gonna help close us out. So first, we're, just a very, very general question, what happens to your assets when you die? And, in general, for most people, it depends on two things, whether you have a will or you don't have a will. If you don't have a will, it's known as being intestate. That's what that term means. That's how it is understood under Illinois law. And if you don't have a will, your assets go to your heirs as Illinois law defines them. So, for example, if we have a two-parent, two-children situation and one parent passes, what Illinois law says is 50% of the deceased spouse's assets go to the surviving spouse and 50% get split among the children. It's not necessarily all to a surviving spouse by default. So, that's where a will would come into place, because most people who might be married will typically want to provide everything to their surviving spouse before assets would go to children, who might not be the right age to receive assets or might not legally be able to. So a will is instructions to a probate court about, what you want to happen to your assets and who you want to be in charge of it. And a probate court acts as kind of the referee, to make sure that everything works according to what the will says and everyone does their job. There are ways, obviously, so testate and intestate. So that's the other thing, is we call it being testate if you have a will. So there are, and then I kind of jumped into this a little bit, who your legal heirs, spouse and children. Stepchildren aren't typically included in that unless they've been legally adopted. If there are no spouse or children, go to parents and siblings. And then if a sibling's not around, it drops down to their descendants, so on and so forth. There's a whole very boring section of the Illinois Probate Act that kind of sets all this out, in case everyone ever needs to fall asleep. It makes for some good reading. So these are some terms now. So who are your legatees? A legatee is the name of someone you leave something to under will, and another term for that is the beneficiary. But in the terminology, when we're talking about a will, it's called a legatee. That's what we refer to a beneficiary as. So now we're going to jump into, we have a will or we might not have a will. What does probate look like? That's where we've ended up now.
Thank you, Brian. So I'm going to talk about how probate works. In Illinois, anyone that owns real property in their individual name or owns assets over 100,000 in their individual name without a proper beneficiary designation will have to open up a probate estate. Having a will in itself does not avoid probate. The only way to avoid probate, as I mentioned, is to not have real property in your individual name and have under 100,000 in assets. If that is the case, you can fill out what's called a small estate affidavit and you can avoid probate. Probate is a process by which a court grants authority to an individual to transact on behalf of a decedent. And just some terminology, a decedent is an individual that passed away, and the person that is going to be appointed by the court, they're generally referred to as the representative. If there is a will, the representative is referred to as the executor. If there is no will, the individual is referred to as the administrator of the estate. So the first step is to determine if probate is necessary. Like I mentioned, you would have to see how many probate assets you have versus non-probate assets you have. You'd have to consider your real property, see how it's titled. And one last thing, you would also want to see if there is any potential cause of action. So an example, if someone dies in a car accident, the representative of the state might want to file a lawsuit for wrongful death or survival. If that's the case, a probate estate will have to be opened, as the plaintiff in that case will have to be the representative of the state. In Illinois, upon someone dying, the person that has original copy of the will has to file it within 30 days. And the next question then is, where do you file a will? You have to file it in the proper venue, and venue is proper where the decedent owned real property, or let me take a step back. It's proper where the decedent resided, or where the decedent owned real property. If the first two don't apply, it's going to be where the majority of the personal property of the decedent is located, okay? And so you're going to have to work with an attorney to open up the probate estate. It is something that we specialize in, so please keep us in mind. Prior to opening up a probate estate, you want to ask the following question. Is there a nominated executor under the will? Once again, an executor would be the person or individual that administers the estate, and they're referred to as an executor under the will. If there is no will, how do you know who can act as administrator? The Probate Act spells out a list of individuals who have preference to act, starting with the surviving spouse, followed by the children, grandchildren, parents, brother, and sister. So, after you figure out if there is a will and executor, if there's no will and administrator, you have to see if that person is willing to act, first off, and then you have to find out if that person is qualified to act. Whether you're an executor or administrator, in order to be qualified to act, you have to be 18 years of age, resident of the United States, not of unsound mind or disabled, and you cannot be convicted of a felony. Afterwards, you would ask who the heirs, legatees, and beneficiaries are of the estate, and you would want to know if any of the heirs are predeceased or unknown. And the reason you want to know that, with your petition to open up the decedent's estate, you'll have to file an affidavit of heirship, which shows who survived the decedent. You'll also have to give notice to anyone that has preference to act over you. And once you open, you will also have to give notice to the heirs and legatees. Lastly, you're going to want to consider if a surety bond is required of the representative. So under a will, a typical will waive the bond, and a bond will not be required. Otherwise, if there is no will, the representative of the state will have to obtain a bond for 1.5 times the personal property of the estate. So for example, if an individual passes away without a will, their surviving spouse, let's say they petition to open up the estate, would look at the personal property, the approximate value of the personal property of the decedent at the time of death, and let's say that's 100,000, the bond will have to be for 150,000.
So just jumping in super quick to what Jonathan was talking about, a surety bond is basically insurance for the executor or the administrator, that they're doing their job and going to, manage assets in the right way and distribute them to the intended beneficiaries. It's a layer of protection that is always required when you don't have a will. It can sometimes be required if a will does not waive a surety bond. So oftentimes, it's important to think, who you want to name as your executor in a will in which you waive surety, in case, that person may not, do the best job, and, they're not necessarily going to be backed by, insurance in case something happens to estate assets under their watch.
Thank you, Brian. And similar to insurance, you would pay a premium on the bond. It would be a yearly premium. For example, just giving rough numbers, a bond for about $7,500 is about $100 for a yearly premium. So moving on, once the estate is opened, the representative of the state will receive orders appointing them. If there is a will, the order will admit the will, and letters of office will be issued. Letters of office is going to be the piece of paper that essentially gives you authority to act as the representative of the state. You'll be able to take that piece of paper, go to a bank or any other, DMV, anything like that, to show that you are the representative and you have power to collect the decedent's assets for the purposes of distribution pursuant to the will or pursuant to Illinois law. After opening, creditors of the decedent need to be notified. So if you do know who the creditors are, you have to give personal notice. And on top of that, you also have to publish in the Daily Law Bulletin or Herald for any unknown creditors.
Yeah, basically any newspaper that circulates in the county in which the person passed away and probate's being opened.
Mm-hmm. And by doing so, it starts the claims period. It's going to be a 6-month time frame where any creditors are able to file a claim against the state. And if they don't do so within that time frame, they're going to be time barred from it. After the claims period expires in 6 months, the administrator or executor is free to transfer the assets to the rightful heirs, beneficiaries, and or legatees.
Yep, exactly right.
And so some things to keep in mind if you are the representative, you are never personally liable for the debts of the decedent. What that means is we don't want you to be paying for the decedent's debts out of your own pocket. We want to make sure that we keep your money and the decedent's money separate. The assets of the estate must be used to satisfy the estate debts. So during this 6-month time period, the representative is going to collect all the assets and discover any assets that the decedent owned in their individual name. And from there, they would start by paying off the decedent's debts after the expiration of the 6-month claims period and go from there before they distribute to any heirs or legatees. And typically creditors have 2 years from the date of death to file a claim, but by publishing, like we just mentioned, it shortens this time period to 6 months. Claims are classified based on priority into 7 categories. And this is important, especially if the state doesn't have enough assets to pay off all debts. If that's the case, there's going to be 7 categories, and you would pay out based on the priority of the classification. So for example, funeral and administration expenses would be class 1 claims. And then following that would be surviving spouse and child's award. And the Probate Act spells out 7 categories, and you would pay out according to those categories. So as the administrator or executor, you have a fiduciary duty to all the beneficiaries of the estate. You don't owe, one heir more over another. And you want to make sure that, like I said, you don't commingle funds, you keep good records, and you do everything, in line with the Probate Act and in line with the will if there is one. Last thing to note, the time frame to close an uncontested estate is typically 14 months. I know that seems a lot longer than usual, or what people expect. The reason for that, first off, there is the 6-month claims period where assets cannot be distributed. I'm just going to close off with some common myths about probate that are actually false. Number 1, the government takes the assets as a last tax to the decedents. That is not the case, as as Brian shared. If there's a will, you'd follow the terms of the will. If there's no will, the Probate Act spells out who the heirs are and what the distribution is.
Exactly right. If you don't necessarily have a will, it's not that your assets go to the state. It goes to who your heirs are as defined under Illinois law.
Correct. And number 2, an heir's inheritance is taxable income to the heir. This is false, but an estate may incur an estate tax depending on the size. And this tax liability is payable by the state rather than the individual. Number 3, if a will isn't filed, the decedent's assets are fair game. And number 4, the decedent's debts die with them. As explained before, upon collecting all assets, the close of the claims period, you'd have to pay off the debt before any distributions were to occur.
So 1 or 2 quick things about taxable income when it comes to inheritances. So most inheritances won't be taxable income to the heir or to the beneficiary. Things like life insurance proceeds, cash, those are not treated as taxable income. When we talk of, there are some other assets that typically will not generate tax too, things like a home, stocks, that are held in a brokerage account. Those types of assets get what we call a step up in basis to the fair market value of what they're worth on the day of someone's death. So that if a home, for example, is sold, within a year of someone's passing, it will generally not be taxable income to anyone. But if you hold on to something long enough and it appreciates, in value, if you hold on to it for a few years and it's worth more, there might be some capital gains that's generated there because that step up in basis only happens one time. And that step up in basis, as I said, is also applicable to stocks that are held in a brokerage account. Now, if you have stocks that are owned through like an IRA, something like that. So IRAs can generate taxable income to people who are named as beneficiaries. And that's because income tax was never paid on those assets. So basically, as a beneficiary would draw down on those, IRAs, take required minimum distributions and things like that is reportable income just because there was no estate tax paid on it when that income was earned. So as with most things, there's sometimes a little more to the answer, and just want to make sure you guys have it all. So now I'm going to talk a little bit about trusts and how trust administration works. So a couple ways to avoid probate, and a trust is one of them. A trust is basically an arrangement, where you have a person, you have a couple parties involved. You have your beneficiaries, you have your trustee, and you have the person who creates the trust, who's sometimes called a grantor or a settler. So it's basically a trust is an agreement between these three people as to what's going to happen to an assets during the grantors or the settlers, the person who creates the trust lifetime, and what happens on their death. It's another way to leave assets to beneficiaries, sometimes with rules attached to it and more conditions, without going through probate. It's basically, I call a trust sometimes a super beneficiary designation. It's a beneficiary designation that is many pages long and says what happens if something happens to certain beneficiaries. Like if a child dies and there are grandchildren, that child share would go to the grandchildren and maybe be held in trust until they turn 21. So, there are places for trusts, and they can save you a lot of headaches, save beneficiaries a lot of headache. They're confidential documents where wills are not. So trusts are never filed anywhere, but a will is filed with the county, like Jonathan was talking about. And if a trust is properly funded, we can avoid probate. And by properly funded, we mean that either an asset has been retitled into the name of a trust, like a home, it would reflect, like my trust could say the Brian Warens Revocable Trust, or you can put the trust down as a beneficiary, like on an account, if the account's beneficiary designation doesn't allow you to cover the entirety of your wishes, because oftentimes they're very straightforward, mechanical. You can leave a certain percentage to a certain person, but that's, you can't put any conditions on that. If someone, has spending issues, creditor issues, that money going straight to them, could do more harm than good. And the person in charge of the trust is a trustee. That's their job. They're basically the person that follows the terms of the document and make sure that all the distributions are made in the right way, and accounting is provided, inventories are provided, and essentially beneficiaries are informed of the whole process along the way. So now we're going to get a little bit into, a little more granular into what administrating a trust looks like. And in the following slides, I've broken it down by attorney duties and the trustee duties. So the attorney and the trustee are a team, when it comes to carrying out the document. The first thing the attorney does, upon someone's passing, is notifying the beneficiaries that the trust exists. and, send them a copy of it and, explain overall what the trust administration process looks like, give you some expectations, some timelines, some ballpark. So, you're not in the dark and you're involved in the process. An attorney, obtains the tax ID number for a trust during a person's life. Typically, the tax ID number for a trust is their social security number, and that's because you are your trust while you're alive, and it becomes its own entity in the event of death. You can't use a social security number anymore to report income after a person dies, so that necessitates the attorney getting an tax ID number for the trust. The attorney prepares an inventory of assets for the trust as of date of death and provides that to the beneficiaries. The attorney prepares an accounting, basically, that shows all inflow and outflow of assets in the trust from date of death through, when distributions are going to occur, so that you see every penny that comes into and leaves the trust between date of death and when the beneficiary receives their distribution. Believe it or not, there's a part two. So other things that this is the other half of the process pretty much is when we get close to terminating the trust, when we're ready to wind things down, the attorney prepares, the accounting and prepares documents which release the trustee from liability, and that the beneficiary sign acknowledging, that they've received an accounting, they've approved it, they have no questions. And so the trustee has assurances, that they've done their job. No one is going to come at them later, for some perceived slight. Gives you that protection that you need. The attorney sends these documents out, our assistants get it done. So, this is not something that's on a trustee's plate. We try to work with a trustee to, make their lives as easy as possible, because it is a job and it requires a lot of work from both sides, both parties here, the attorney and the trustee. So if concerns do come up and questions do come up, help answer those questions. And once the trust is, substantially wound up, we work to, get the distributions out to beneficiaries, whether it's checks that are picked up at our office, are mailed out, or potentially wired to a beneficiary's account at a bank. And then we, work with an accountant if there are any tax return issues that need to be handled. An accountant is typically the third person who's part of the team when it comes to administering an estate or trust. Sometimes it's a financial advisor too, if you have worked with one during your life. So that's kind of what it looks like from the attorney side. So now we'll talk about what it looks like from the trustee side and how kind of the attorney's duties tie into the trustee's work. So the first thing, the trustee typically does is open up new accounts for the trust using that tax ID number that the attorney got. The trustee gathers account statements, whatever documentation that's needed to establish date of death values. So we have a starting point for that inventory and accounting. The trustee obtains appraisals for any business interest real estate. So I will say you don't necessarily need an appraisal for a vehicle in most cases, but you could get that done too. You could take it to CarMax and get a quote, and that counts as an appraisal for a vehicle. In most cases, Kelley Blue Book works just as well too, for terms of establishing a value for a vehicle. But business interest real estate, appraisals are needed, and we have lots of resources in those areas, and connect you with a few people that we worked with in the past, and will do a good job. The trustee also keeps track of account statements and sends them to the attorney as they come in, because those account statements are what the attorney will use to prepare the accounting for the trust. The trustee liquidates and kind of consolidates all assets that are, you know, in old trust accounts into this new trust account that uses this new EIN. So, you know, the idea is we're trying to create that central repository from which we'll ultimately make distributions to beneficiaries. So a lot of these things end up being a duty of the trustee just because they are the only person that can do them. They're named in the document. They have the legal authority to carry out the wishes of the document. The attorney doesn't. The attorney's job is to advise the trustee how to do their job and what they should be doing, such as preparing the real estate for sale and getting it sold. We also, you know, have contacts with real estate brokers. We have real estate attorneys here, so we're able to, you know, help you with that in-house if needed. You let the trustee lets the attorney know kind of once everything's been consolidated into the new accounts, you know, once we've basically gotten our cash pot together to distribute assets out. And then the trustee will, you know, once we get back that approved accounting, those signed receipt releases, we advise trustees generally to distribute out, you know, most of the assets while retaining maybe a small reserve to pay for any final accounting, attorney's fees, or compensation that the trustee is taking, because again, it is a job, and a trustee under pretty much all trusts are entitled to reasonable compensation for the work that they do carrying and doing this job. And then once the trust's final tax returns are approved by, you know, IRS and IDOR here in Illinois, then any assets that are held back for those final expenses, they're distributed out and we're done. And it's a lot of work to get to that point, but with trusts, you know, you can get it done a lot quicker than the probate process, which, like Jonathan mentioned, can often, you know, go out to 14 months. We administer a lot of trusts, and oftentimes if you have everything in a trust, you can cut that process down to under 6 months in a lot of cases. That's what I got for trust administration for now, and I know there will be questions.
Thank you, Brian. Okay, so up until now, we've been hearing about trust administration, probate administration, and these are all scenarios where you have passed on and your assets are now being distributed according to the plan you set out. However, there is a step that happens in between that can happen, and that's incapacity. So that's a situation where you are still living, you haven't passed on, but you are incapacitated, or in other words, unable to carry out your affairs, unable to make decisions for yourself, unable to manage, you know, your finances, or even communicate with your medical providers. And I always, when I'm talking to clients about incapacity, I like to explain, you know, we like to plan for every possible scenario in estate planning, and incapacity is that awful dark what if, you know, horrible car accident, you're still living, but you're on life support or in some condition where you can't advocate for yourself. And typically, when we're doing that type of planning and anticipating all possible outcomes, the solution is powers of attorney. But if you haven't done that planning, like you haven't done a will, you haven't done a trust, in incapacity terms, if you haven't planned for that what if moment, the solution then becomes guardianship. And so guardianship is what comes after you've been incapacitated or you're under some form of disability, and you need to have someone who can be your voice. Guardianship is a court proceeding. It is done in probate court, and it's basically a process where a loved one, a person, is seeking court authority to make decisions on behalf of the other person that is under the disability or incapacitated. So the terminology here is the guardian is seeking guardianship over the respondent, or if the guardianship is entered, over the ward. And guardianship can be over the person to make decisions, medical decisions. It can be over the estate to make financial decisions, and it can be both. And it could also be in varying degrees. It can be limited guardianship, where the person who is subject to the guardianship, the ward, can still make some decisions on their own, or it can be a full plenary guardianship, where the individual is completely under the decision-making power of another. Now, guardianship is a very long and delicate process, because essentially what you're doing is you're taking this adult who's had full autonomy over their person and their assets and reverting them back into essentially a minor in the eyes of the law, because someone who is subject to a guardianship, you're transferring their decision-making power to another person, the guardian. So the person under the guardianship cannot, for example, own a bank account. They can't have a driver's license. They can't vote. They can't enter into contracts. So there's a lot of civil liberties that are being removed from that individual and being given to another person. So in fact, the process to obtain a guardianship involves an independent medical evaluation, where a neutral physician is confirming that a guardianship is the right solution. Similarly, the ward or the respondent, they get personal service. So they're served with a copy of the court proceeding and the records that shows them, hey, you're being subjected to a guardianship proceeding, and here are your rights, including the right to retain an attorney and contest that, and preserve your rights as an autonomous adult. So guardianship is the solution when there hasn't been planning done, and it's a very extreme solution, but also very helpful for a loved one in need who needs that support right away. The alternative, the planning alternative, is powers of attorney for healthcare and for property. And powers of attorney are instruments, they're documents that you prepare in advance as part of your normal estate planning process. And they are executed by the principal, the person creating the power, and it's where that principal is appointing an agent to make decisions on their behalf upon some triggering event. So when you prepare a power of attorney, you can set forth the parameters that say, my agent can make decisions on my behalf concerning my health or my property upon a finding of me being incapacitated, or upon a finding by my physician and my loved one that I'm unable to carry out my affairs. So there's that protective language that says, only when this happens will this agent be vested with the authority to make decisions on my behalf over healthcare, financials, accounts, personal property, things of that nature. So there's the two types, medical and financial, and it's a very pragmatic planning tool, because you can do this in advance for just taking care for that day that you hope never comes, but if it does, you don't have to go through a court proceeding. Now, powers of attorney are a very powerful instrument, and so I do want to give a word of caution to our agents. When you are appointed an agent, you're appointed in what's called a fiduciary role, and we've heard that role, that term throughout this presentation. And that's basically, you have the highest responsibility owed to your principal, the person giving you this power. So first of all, when my clients come in and they tell me they've been appointed as agent under a power of attorney, I remind them, it's not your money. It's the principal's money. It's their money, and they're trusting you to make decisions for them in their best interest with their money. So with that in mind, I also tell my clients, keep detailed records. Keep detailed records about everything you spend, every decision you make, and everything you transact on behalf of the other person, because under the Illinois Power of Attorney Act, powers of attorney are responsible to keep records for every transaction they undertake in their capacity as agents. And you must be able to demonstrate that you've been carrying out your duties for the best interest of your principal. And you must always act in their best interest because of that responsibility that's placed on you as an agent. I've had a case where I had a client who came in and had been appointed agent years ago. Oh, I think it was 8 years. And it was a contested dispute, and we had to produce an accounting spanning 8 years of transactions. So detailed record keeping is so critical, because it's really a position where you're transacting for someone else.
Yeah, and just to jump in quick, it's every bit a job as being a trustee or, you know, a representative of an estate is. It's just during a person's life while they're incapacitated. And people often don't get powers of attorney soon enough. I will say, we advise, our clients that as soon as you have a child that turns 18, they need a power of attorney, because you're not able to make those personal and financial decisions for them if anymore. And in the event they become incapacitated, they still need, you as the parents to advocate for them. So it's, as soon as they hit 18, that's as early as we do recommend powers of attorney.
Yes, and just piggybacking off that point, we've had many parents who, they send their kids off to college, and then their kid is, living independently, they're away at school, they don't have powers of attorney in place, and then you find out, oh, your kid's in the hospital, they went skiing and broke a leg, and you can't get access to information, you can't get access to the records, they won't tell you anything, because your loved little baby is technically an adult in the eyes of the law, and you don't have a power of attorney that allows you to make medical decisions on their behalf or access medical records. So this is a critical planning tip for parents that have children coming out of that minor age that, are still very involved parents, but their child is now a legal adult. And so then that's basically what powers of attorneys are. And this whole time we've been talking about different concepts of estate administration. So we've talked about probate and what it looks like to go through a probate proceeding when you have a will or when you don't. Then we moved into trust administration. So if you prepared an estate plan and you have a trust, what does that mean? How does that work? And then powers of attorney, if you're incapacitated, what happens? This is all estate administration. And as I mentioned at the beginning of this presentation, my area of practice is contested estates. And contested estates is basically when you have a dispute, a form of a lawsuit or a litigation within a component of an estate administration. So in the most basic example, it would be, for example, a will contest. That's essentially where we have a will, it's been filed with the court, and there are interested parties in the estate that are contesting the will. They believe that the will is invalid under the law. So they're bringing a cause of action to say, well, this will was prepared when my loved one was incapacitated. They were suffering from a mental illness and didn't know what they were signing. Or this will was prepared under duress or undue influence. My loved one had a roommate living with them, and the roommate got them to sign this under pressure. So this will is invalid for those reasons. Similarly, we may have guardianship litigation where one person is seeking to be appointed guardian of another, and another relative or interested party comes into the case and says, no, you're not fit to be guardian. I'm the better fit. I've taken care of this person for this many years, and you have a gambling problem. You're going to run off with their money, So it's litigation within an estate administration component. Similarly, powers of attorney, there can be a lot of litigation concerning the use of someone else's money under an agency. I had one case where it was a client that was acting as power of attorney. Wasn't my client was a loved one, and we later learned that agent had completely spent out their parents' funds on lavish trips across the world, expensive purchases, lavish gifts, and all that time the parent was in a long-term assisted living facility, and unaware that this was happening to the estate that she had properly planned for and prepared to be distributed to her children in equal shares. But when she finally passed, the children came to learn that there was nothing to be had because this agent had blown through the savings. And so that was a dispute to basically claw back the assets that were improperly spent by that agent under the powers of attorney. And similarly, you can have the same kind of dispute with trust administration. You know, a trust we've talked about is this instrument that you prepare all of your beneficiary designations in. It's that super beneficiary designation that Brian talked about, and all your gifts and bequests and wishes can be disseminated through this trust. But it's always contingent on the trustee carrying out those duties and following your wishes and doing what has been said to have been done in that trust. So if you are ever finding yourself in a position as trustee, you want to work with an attorney to make sure that you are doing everything under the trust, but also complying with the Illinois Trust Code. There's always an overarching law that is applicable to these roles. So in probate and guardianship, it's the Probate Act. In the powers of attorney, it's the Power of Attorney Act. And in trust administration, it's the Illinois Trust Code. So all these roles and all these tools also have a whole body of law that's outside the instrument, outside the will, outside the trust, outside the POA, that is still applicable and controlling in how that instrument is used. So if you don't want to find yourself in a contested estate situation, but if you do, these are the type of things that you're going to be running into. And your best protection to not find yourself in a contested estate situation is to definitely work with an attorney that can guide you through these critical roles and these critical decisions, and also have a mind towards the applicable law that's overarching all of this. And
help you discover those potential situations, you know, in your own family that could lead to issues later.
Exactly right. Because unfortunately, when you're with your family, you know, you see only the best, and you're seeing everything play out as you want it to, hopefully. But we've seen a lot of families that when there's something that is just not being communicated right, or there's some kind of transaction that becomes an issue, unfortunately, it can break bad. And that's where working with an attorney, we can have the foresight to protect you and get you in a place where you won't be exposed to liability in that way. And in that vein, I want to point out a few best practices to help you stay out of court and stay out of a contested estate, and not have to hire me. Communicate. I can't tell you how often I have clients come in and tell me, oh, you know, my sister, she has it out for me. She doesn't trust me, and I'm the trustee or the executor of this estate, and she's just overreacting. And I say, okay, well, have you given her a copy of the trust? No. Have you told her that she has an interest in all this? No. Did you tell her how much money is in this estate? No, it's none of her business. I'm the trustee. Wrong. It's definitely her business. You have to communicate. And if you think about it, at us as, you know, humans, whenever we don't have information, or whenever there's silence, our immediate instinct is to fill that silence with a negative assumption or a negative thought or a suspicion. So whenever you're not communicating, that is still sending a message to another person of perhaps you're withholding something, or perhaps you're stealing, or perhaps you are keeping something out of their reach, or you don't want them to know about something that they are entitled to. So the best practice that you can do is communicate, be transparent, explain what's going on, and have that open dialogue, because that's how you calm concerns and calm suspicion. As trustee, as executor, as agent, that doesn't mean that it's all yours. It just means that you're the one stuck doing the work to make sure everyone gets their share. You're the one that's responsible. You're the one that's being held accountable. So please communicate. And then save records, receipts, and correspondence. I can't tell you how many cases I've had where my clients tell me, oh, well, I told all the beneficiaries at Sunday dinner that this is what they were getting. And I said, okay, that's nice. Did you have a court reporter transcribing Sunday dinner? No. So there's no proof that you told the beneficiaries what they're entitled to. There's no proof that you showed them a copy of the trust and showed them their rights. So please, I know family is a very informal environment, and it's okay to talk about stuff at Sunday dinner, but follow it up with an email, follow it up with a correspondence, send out copies of receipts and invoices, keep them informed in writing. And with that, I want to say, put everything in writing. If you are giving them an official communication about, hey, here's what's available in this account when mom died, then put that in a proper letter, or work with an attorney who's going to prepare the proper notice that's going to comply with the Illinois Probate Act to give them that information. Because that's the way that you're showing that you're carrying out your duties, you're documenting what you have to do, and you're showing that everyone involved has the information that they need to have when they need to have it. And with that, work with an attorney, because we know these statutes, we know these acts in and out. We deal with them every day. We see how they get used, how they get stretched, how they get interpreted, and seeing how this plays out, we have already so many tools to help you prevent getting into a situation that you find yourself where you're subject to a lawsuit or subject to liability. So working with an attorney to guide you is critical. I have just one other case that I'm working with a lovely woman, super kind. Her siblings are, up in a roar with her, and they're upset because there was a trust that was never communicated to them. Parent passed away years ago. They had no idea that this trust existed, and now the siblings are in litigation. And she keeps saying, I don't understand this. Why are they so upset? And I said, well, you never told them that this thing existed. And she says, well, I didn't know. And not knowing is a perfectly fair reason. I understand why you didn't do it, but it's not a defense. So the best way to prevent being in a situation where it's too late and you just didn't know is talk to an attorney. We'll tell you. We'll make sure you're doing the right thing. And with that, I want to open it up to questions.
And then we'll stop the recording.
Yeah. 1 second, bear with me.